Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 92. How nice it is to see spring has finally sprung by all accounts. Lambs gambling up and down Bishopsgate and ducklings on the Liverpool Street Station Lake. In business sense, our three cases this month concern the appeal of the High Court case that we've covered previously about damages for breach of restrictive covenants. We've also got a case on whether an employer fairly dismissed an employee when they thought, possibly incorrectly, that the employee was no longer permitted to work in the UK. And finally, we've a case on an employee's right to manifest her religious belief at work. As usual, don't forget you can access the podcast via iTunes, the Mayor Brown website, or YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, which is also where we post out links to all the cases discussed. So our first case, Morris Garner and One Step Support Limited. This is the case. We covered this at the High Court stage. We now have the next stage in the story. And for all the reasons that I thought this case was important when we first covered it at the High Court level, it remains, if anything, even more important at the Court of Appeal because of some of the comments made by the Court in coming to its decision. The background is that, as decided by the Court, Karen Morris Garner and her partner built up a business in providing support service for young people leaving care. They sold the business, and business was called One Step. They sold the business and then they worked alongside the new owners of the business, but, as so often happens, relationships broke down. Covertly, the two defendants set up a company, July 2006, called Positive Living, although I don't think they traded at that point. The defendants then sold out their residual interest in the One Step business to the other owners and agreed they would not, for 36 months, engage in material competition with the company or canvass or solicit clients or customers. Obviously, the covenants were more detailed than that, but that's the general gist of them. By spring 2007, i.e. within just over 2 months after selling up, Positive Living, which was the company that set up covertly, started marketing and applying for the necessary qualifications to trade. And in 2010, i.e. 3 years later, the defendants sold their shares in that company to a purchaser, and the sale price apparently was somewhere north of £12 million. However, in late 2007, One Step had heard about Positive Living, but when challenged, the defendants denied that they were acting in breach of their covenants, and this explanation was accepted to the extent that that One Step didn't pursue the matters at that point. Unsurprisingly, perhaps, One Step business starts to suffer, and One Step claims subsequently, and with the benefit of hindsight, that this was due to the undisclosed competitive activities of the new Positive Living business set up by the defendants. So, in 2012, i.e. after the expiry of the restricted covenants, the One Step business brought a claim against the individual defendants for damages. There was no injunction application, and the High Court, if you remember, ruled against the defendants. It decided there had been breach of the covenants, there were valid terms, and awarded damages on the basis of the Rotham Park case, which I'm going to explain in a second. The defendants appealed to the Court of Appeal against that damages award, and the bulk of the argument consisted on whether damages should be awarded, and if so, how they should be calculated. The background, of course, is that typically in restrictive covenant cases it's extremely difficult to prove that a client has left the business because of wrongful solicitation or actions in breach of a non-competition covenant. The response from the defendant will always be that the client was likely to leave the business in any event following the departure of the individual concerned, irrespective of whether they were not solicited by the individual. If the solicitation did not cause a loss, then no damages flow from the solicitation and therefore no damages. The claimants based their case for damages, however, on the Rotham Park case. Now, this isn't an employment case, but it illustrates how the damages in such circumstances can work. In the Rotham Park case, land was sold, which had a restrictive covenant, preventing that land from being built on without the prior approval of the vendor, who retained the neighbouring land. The parcel of land was built on in breach of the covenant. However, the original landowner's land, which he continued to hold, was not diminished at all financially as a result of the development, and the judge assessed damages on the basis of what might reasonably have been demanded by the plaintiffs as a quid pro quo for relaxing the building restricting covenant. So you think of Rotham Park damages as a notional fee to buy out the relevant restrictive covenant. You've got the idea. Well, the Court of Appeal in this case upheld the approach by the High Court, saying that the award of damages on a Rotham Park basis was the, quote, just response in this case, unquote, and that was the correct test, according to the Court, for deciding whether or not Rotham Park damages should be awarded. The judge was entitled to take into account the difficulties which One Step would have had in establishing damages on an ordinary basis. These difficulties did not need to be insuperable to enable a Rotham Park damages approach. The Court did confirm that a Rotham Park damages award would be an unusual remedy, and that if damages were awarded in this case on a Rotham Park basis, it could be argued it would make the exceptional the norm. However, it's clear the Court of Appeal does still view the Rotham Park route as the abnormal rather than the normal route. They point out the test is not what is exceptional when deciding whether to grant Rotham Park damages, but what justice requires. Lord Justice Longmore, one of the judges in the case, said that there were three important factors recognised previously by the courts in deciding whether or not to award Rotham Park damages. There had to be a deliberate breach by the defendant of its contractual obligations, the claimant would have to have difficulty in establishing financial loss, and the claimant had to have a legitimate interest in preventing the defendant's profit-making activity and breach of contract. Here he also drew attention to the, quote, subterfuge and furtiveness, unquote, of the defendants, which effectively deprived One Step of the opportunity to earn interim relief. And he said he felt this was an important feature, but not an essential one. So, standing back, what does all this mean? Well, first, defendants who are debating whether or not to act in knowing breach of restrictive covenants, but in a covert fashion, need to take account of the fact that a court may in effect levy a fine on them for their activity. Of course, it wouldn't be put like that, but a court will decide a hypothetical sum of money based on what a claimant would have accepted financially in place of a valid restrictive covenant. Secondly, it gives claimants an alternative option. Sometimes the damage may have been done, and even if the competing and wrongful activities are restrained by an injunction for the balance of the covenant, that merely puts off the evil day when the competition can start up again. It's not unusual to find that if a defendant has been unlawfully competing for, say, between 2 and 4 weeks before an injunction is granted, this punches a hole in the ring face which the defendants would have wanted to place around their clients. Which the claimants, I should say, would have wanted to place around their clients, and during which time the claimants, the old employer, would have had a completely uninterrupted period free of interference by the defendant. Thirdly, however, and one of the points which I must say was of concern to me when I read the original High Court judgment, was the fact that this case might be used by defendants as a defence to a restrictive covenant injunction application. If claimants seeking an injunction need to show that damages would not be an adequate remedy in order to obtain that injunction, the existence of Rotham Park damages might seem to push against this. However, the Court of Appeal did not accept that argument here. The test when applying for injunction is whether ordinary damages are an adequate remedy, i.e., quote, as assessed in the ordinary way, unquote. The court said, quote, I do not regard a decision in the present case upholding Rotham Park damages as meaning that injunctions which would otherwise be granted are likely to be refused, unquote. So in this sense, the case is nothing but good news for claimants who are given an option, potentially, of an alternative remedy. It's something employers should definitely be looking at as a way of effectively enforcing restrictive covenants in appropriate cases. So, next case is Wasteney and East London NHS Trust. This case looks at the difficult issue of the extent to which an individual is entitled to manifest their religion or beliefs at work, and at what point that manifestation, that behaviour, crosses the line into unacceptable conduct, particularly where it's objected to by other employees with equal but different beliefs. This is, of course, the employer nightmare scenario. Two individuals, both with protected beliefs or protective status, assert that their beliefs or status is not being respected, and there's potential irreconcilable conflict. What is an employer to do? Well, this case is a really good example of an employee who goes too far, and the employer's disciplinary action is finely honed, is absolutely spot on, and the employer's disciplinary action as a result is not unlawful. So, The facts? Well, claimant works for the respondent. She describes herself, according to the court, as a born-again Christian. She's a member of an evangelical church. As a result of what were found to be inappropriate behaviours, she was given a final written warning, which was subsequently reduced to a written warning. But nonetheless, the case goes off to a tribunal. Now, the underlying facts then, June 2013, a complaint is made by a junior occupational health therapist who describes herself as being of Pakistani heritage and Muslim faith. She asserts the claimant has been trying to impose religious views on her. She submitted an 8-page document which, among other things, referred to her as being, quote, groomed, unquote, by the claimant, who was in a managerial position senior to her. As a result, the claimant said, she began to feel ill. After the disciplinary action imposed on the claimant brings tribunal proceedings claiming that she had been harassed and directly and indirectly discriminated against by the employer. It was also alleged there had been a breach of Article 9 of the European Convention on Human Rights. So, in a nutshell, the claimant, evangelical Christian, appears to be trying to convert someone of Muslim faith. That person complains. The claimant, the evangelical Christian, is disciplined. The evangelical Christian goes off to the employment tribunal claiming breach of her statutory employment rights. Well, the tribunal dismisses the claimant's claims. It accepted that the context of the disciplinary process against the claimant was her religious acts, but the reason for her treatment was because the employer felt those acts blurred professional boundaries and placed improper pressure on a junior employee, rather than that they were simply religious acts. The tribunal said they had no doubt that the employer would have taken a similar approach had the claimant been pressing a particular political point of view. As a result, the tribunal dismissed her claims and she appeals to the AT. Well, the main basis for the appeal in the AT was whether the employment tribunal erred in law in saying that the claimant's religious belief was the context for this, rather than being the exercise of her Article 9 Convention rights. And secondly, the appeal was on the basis of whether the employment tribunal had failed to properly test the proportionality of the respondent's response in terms of the disciplinary sanction, and specifically by failing to consider mediation as an alternative to a disciplinary sanction. Background? Well, as background, Article 9, of course, is the right to freedom of thought, conscience and religion, and the right to manifest religion or belief in worship, teaching, practice and observance. Under Article 9.2, this is subject only to such limitations as are prescribed by law and are necessary in a democratic society in the interests of public safety, for the protection of public order, health or morals, or, and this is the important part, for the protection of the rights and freedoms of others. The Employment Appeal Tribunal accepted that Article 9 protects both the right to hold a particular belief, but also the right to manifest it. They also accepted in certain circumstances a right to manifest a belief could include the right to attempt to convince others of the tenets of that religion. However, because of Article 9.2, this freedom is qualified, it's not unlimited. Fundamentally, the appeal failed because of the findings of fact by the Employment Tribunal that the employer, the respondent, had taken disciplinary action against the claimant, the Christian evangelist, because the claimant's colleague, the complainant, had made serious complaints about acts which blurred professional boundaries and placed improper pressure on her. Mediation was clearly not appropriate in the circumstances, given that the complainant was no longer working at the organisation, and the claimant had to accept that a final written warning, reduced to a written warning, was not, by itself, oppressive. Well, I wanted to run through this case simply to give an example where the potential for a nightmare scenario existed, but the employer behaved very sensibly in coming to the conclusions it did on the facts as found by the Employment Tribunal. You had an evangelical member of one faith trying to convert someone who clearly, in the view of the Employment Tribunal, was not interested in being converted. Given that the person attempted to convert the other employee was the more senior of the two, it was pretty clear that some boundaries needed to be set. Here, once the tribunal had found that the recipient of the religious counselling was unwilling and was therefore feeling pressured inappropriately, it was clear the employer ought to be looking to protect the rights and freedoms of the more junior employee to hold and to manifest her religion or faith. In the circumstances, describing the claimant's religious acts as the context of disciplinary action rather than the reason for them seems to me spot on. The other point to mention is the wholehearted acceptance by the EAT that Article 9 brings with it a right to manifest belief at work, and there's no distinction in these purposes between the right to hold the belief and the right to manifest it. And I think this is quite a useful reminder. You sometimes hear about the difference between the right to hold and the right to manifest, and the EATs having none of it here. I think the takeaway lessons for this is that going into such a potential conflict with a dose of common sense on the part of the employer can never go amiss. Equally, individuals have a right not to be required to participate in particular religious discussions, particularly if they are contrary to their own views. Counselling an evangelical individual to modify their behaviour, maybe doing it informally to start with, and explaining that this is necessary despite their strongly held views on what is right and wrong, may be an essential first step. But after that, in line with Article 9.2, the right to manifest religious belief is subject to the rights and freedoms of others to have their religion or beliefs respected too. So that's the case of Wasney and East London NHS Trust. Third and final case, Nyack and Royal Mail Limited. This is also an EAT case to do with an employee's right to work in the UK. It deals very neatly with the difference between dismissing an employee because they do not have the right to work, which would fall under Section 98(2)(d) of the Employment Rights Act 1996, and a dismissal for some other substantial reason, an SOSR dismissal, which is Section 98(1)(b) of the Employment Rights Act. The employee starts working for the respondent 7th of January 2008, and at that point he had a work visa which expired in April 2009. He made an application for a visa which in turn expired in 2010. He then applied for a further visa which appears not to have been granted willingly, but he successfully appealed the original refusal, at which point the visa application goes back to the Home Office at that point for them to take a decision. That goes back to the Home Office in May 2011. By the time of dismissal, in August 2014, nothing further had been heard from the Home Office, and the claimant believed that whilst his visa was being considered, he had the right to remain until the outcome of that application. The respondent, the employer, had a general policy of ensuring every 6 months that individuals who had a right to work in the UK, they would check up on this, although the policy was stricter than the actual legal requirements, which didn't require such a rigid checking process. However, the employer's policy was found to be a responsible one, designed to minimise the risk of someone being employed illegally. Accordingly, the respondent wrote to the claimant in 2012 and 2013 on a number of occasions. The claimant did not respond because he'd taken the conscious decision not to chase up the Home Office to find out the outcome of the visa decision, according to the Employment Tribunal. And this stalemate continued for nearly 2 years, with the employer writing on numerous occasions to the individual, asking for an update, and the claimant failing to respond. He was then interviewed by the employer about his failure. This pointed out to him that since his original visa application had been made coming up for 4 years earlier, it was increasingly dangerous to assume that the visa actually remained pending and undetermined. The individual appealed internally, and then after the appeal was given a 42-day period to provide the necessary documentation. The idea for a 42-day extension period was that he could put in an application under the Data Protection Act using the subject access rights to obtain confirmation of exactly where the process had got to. But the claimant decided not to do this. On that basis, the claimant was then dismissed because, in the view of the employer, there was insufficient evidence available to it at the date of the dismissal to allow the employer to believe that the individual had the right to work in the UK. The employer did not dismiss him on the basis that, as a matter of fact, he had no right to work. Accordingly, the dismissal was not a dismissal on the basis that the individual was statutorily prohibited from working. Instead, the dismissal was for some other substantial reason which justified the dismissal. The Employment Tribunal rejected the claimant's claim, and the EAT accepted it had been entitled to come to that decision. The claimant asserted that the employer's checking procedures, to the extent they were stricter than required by law, should not enable the employer to justify the dismissal where he believed he had the right to work. However, the EAT accepted there was more than sufficient evidence to justify the dismissal. The employer experienced that in other cases the visa process had been determined far more quickly, and therefore something had clearly gone wrong here. The employer itself was not allowed to obtain the necessary information from the Home Office as to the state of the application, and the claimant, as he demonstrated many times, was refusing to do so, despite being given multiple opportunities. Well, I wanted to talk about this case in the podcast because clearly here the employer took a very sensible and indeed smart approach to this matter. Had it dismissed the individual because he did not have the right to work in the UK, this might have seemed like the obvious route, but it would have required the employer to determine that point itself, and these were clearly murky waters, to say the least. Instead, once the employer was placing the termination on the basis that it had reasonable and significant doubts about the individual's right to work, it was in a better position to call this, and it was an SOSR reason. And I think the moral from this is think ahead and be correctly positioned when you are looking at terminating an employee to make sure you've thought about how will you position this when it comes to defending a tribunal action if one arises. And here, the easy thing to do would have been the wrong thing, say we're dismissing you because we don't believe you've got the right to work. Far better, as I say here, to put it on the SOSR reason. So the lesson is, think ahead. So those are the three cases. That's Nyack and Royal Mail. Those are our three cases. Thank you very much for listening. I hope to bring you news in the next couple of weeks of a couple of guest podcasts coming up. I also wanted to say, and I do mean this very sincerely, thank you very much to the various people who got in touch with me in the last couple of weeks to say how much they've enjoyed listening to the podcasts. One of the oddities of this series is we have no idea who listens to it. That data is simply not available to us. I'm particularly chuffed when someone obviously enjoys it highly enough to drop me an email with their thoughts. You know who you are. I'm not going to embarrass you by giving out your names, but it is very much appreciated, which is why I always reply to such emails. It's fair to say in the past I've had a few emails which lavish praise on the podcast, then conclude with the dreaded sentence, I'm a trainee solicitor, I'm hoping you can help find me a job, which is understandable, but maybe a little less flattering. Anyway, thank you for listening to this podcast, and I look forward to speaking again in 2 weeks' time. Bye.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.